So at a big picture level, King versus Burwell is a challenge about what the Affordable Care Act says. It's important to understand this is not a constitutional case. It's not a case about whether Congress has the power to do health reform. We had that case in 2012. This is a case about 4 words in a 2,000-page statute. The challengers are arguing that those 4 words operate to punish states that choose not to implement the statute themselves. And to understand the implications of the case, you really have to understand a little bit about the structure of the Affordable Care Act. So the ACA's main reform is that it gets everybody insured at reasonable prices. The way it does this is that it sets up these new health insurance marketplaces called exchanges. These insurance marketplaces vet the new insurance plans, and they dole out critical subsidies to make the new insurance that the ACA provides and requires affordable. An important thing to understand for purposes about the case is that the whole statute is built on a principle of federalism. Out of respect for the states, and in particular, out of deference to their traditional leadership in healthcare, the ACA gives the states the right of first refusal to implement the exchanges themselves. If the states don't do that, the federal government has to step in and do it for them. Another important thing to understand about this case is that health reform's politics are just so unpredictable. So as it turns out, in what has mostly been an act of political resistance, 34 states have decided not to run their own insurance exchanges, and the federal government then has to do it for them. And this is where the Supreme Court challenge comes in. The Supreme Court challenge is also important to understand, is inherently political. It's the direct result of a very publicized strategy to find some loophole, some thread that pulls the statute apart. It's important to remember this is a statute that the House of Representatives has tried to repeal more than 40 times already. So they've lost in the Congress, and this particular battle is now being fought in the courts. So the specific challenge to the statute is this. What the challengers have done is they found 4 words in this 2,000-page law that read in isolation would seem to say that these critical insurance subsidies are not available when the states refuse to operate their own insurance exchanges and instead let the federal government do it for them. The reason this would be absolutely devastating to the statutory scheme is that it would result in the deprivation of health care to 8 million Americans who are currently getting their health care using those subsidies, $25 billion in federal subsidies, and all experts agree this in turn would lead to the collapse of the insurance markets in those 34 states in which the federal government is operating the exchanges. It's important to understand that there's no cooperative federalism statute in history that poses this kind of threat to the states. So the government's response is that it looks across the rest of this 2,000-page act and points to numerous other provisions that clearly indicate that the subsidies were supposed to be available. There's also a long and entrenched line of Supreme Court case law that says when Congress is going to intrude on the states, it has to be crystal clear. In any case other than this one, where it wasn't so politicized, that would make this a really easy case. So in terms of the outcomes of the court's ruling, if the court rules for the government, nothing changes. All Americans can get their health care and their subsidies on the insurance exchanges, regardless of whether they live in a state that operates the exchange for themselves or a state in which the federal government is operating the exchange. But if the court rules for the challengers, there's going to be chaos. As I said before, there's going to be the total impending collapse of 34 state insurance markets. So someone's going to have to do something. This is going to be extremely difficult. The Republicans in Congress can't agree on a health care plan, and as we know, this is one of the most gridlocked Congresses in American history. In terms of the states, while it might seem on its face easy for Republican states to just say, well, we'll operate our own state insurance exchanges now and take care of it, the fact of the matter, these politicians have gained enormous political benefit from resisting the statute, and it's going to be very hard to have them turn around now and decide to cooperate it. So the last option would be that HHS, the Obama administration, would have to do something. But of course, every time they act, they get sued. So it's going to be difficult on all sides. Someone recently compared this to a big game of chicken. We're going to let the Supreme Court rule and let chaos ensue and see who's going to act first. Hopefully, it won't come to that because not only millions of dollars, but people's lives are going to be at stake.